It is May 27th of 2026, and this is the Court Gallery. They say better late than never, but in a courtroom, being late can cost you everything. We'll start with Judge SImpson working through two cases with women in tough situations. Then Judge Webster will deal with a variety of interesting cases from frustrating to kind of funny. Judge Stevens will show us what happens when one defendant is sitting in the wrong courtroom while the judge is revoking his bond in the right one. And finally, a man who is late for a very important date gets a stern lecture from Judge Mogan about tardiness. From last chances to lost chances, we have a wild day in court to check out. And it all starts right now.
Court calls the case, People versus Shannon Kiesling, I think.
Yes, Shannon, this time it is. And Assistant Public Defendant Nick Buckovich on behalf of Ms. Kiesling.
Can you hear me? All right, thank you. All right, go ahead.
Yanni, we are here today for both a bond violation as well as a sentence.
Go ahead.
Prefer I address the bond violation first, Yanni?
Because I'm going to sentence her on the bond violation, correct?
I believe so. So may I briefly approach about that?
Pardon?
May I briefly approach about that?
You may, along with probation.
Yes, Your Honor.
All right, go ahead.
Yes, Your Honor. As it relates to the bond violation, my client will be admitting to the bond violation. We'll be asking that she be able to admit no contest as discussed at the bench, and I'm prepared to address the sentencing recommendation when you are prepared. My client has been in custody for 10 days, so I'll be asking that she receive a sentence for this bond violation for the 10 days, for 10 days of credit served.
All right. Ma'am, is there anything you want to say before I do impose sentence?
You can say no.
Oh, sorry.
It's okay. Anything you want to tell me before I impose sentence?
You can verbally tell him no.
Okay, no.
No. All right. Do you think inpatient's going to help you?
Yeah. I've got my whole family here because I've earned them back. I can't lose them again.
This is your family back?
Very happy. I'm going to school, staying with my family. Got all my kids back, my grandkids. I turned myself in right after my granddaughter's birthday party. I've definitely changed. It was a rough 4 years, and I'm happy now. I just want to move forward.
And we got to keep you on the right track, right?
Hmm?
How soon will we find inpatient treatment for her?
Your Honor, that is organized through the jail.
Jail.
Yeah, I mean, I can contact them, but I don't know that necessarily with someone.
Right.
So I don't know the answer.
All right. Who's that back there with you? All those people who?
My mom, my sister, my brother. My mom's in the short red hair.
Okay.
Sorry. My other sister is in the short red hair.
I got only one redhead.
We're missing one.
Got it. Okay, go ahead.
Missing one.
No.
One in the salt and pepper long pretty hair is my sister, and her husband, my brother-in-law.
No, he's not here.
Oh, he's not. Okay, and my daughter and my son. I think I didn't see them all when I came in, so I'm not sure if they're all here.
That's daughter and son at the end. Okay. You don't have insurance that would pay for inpatient, do you?
Yes, I do.
Do you? Problem is arranging that while she's in. Okay. All right.
John, I was gonna ask for the court, I was gonna ask for the court's consideration of allowing my client to be released to allow her to have some time out inpatient treatment outside of custody because she does have the familiar support system. It is evidenced by the people who are here to support her today. She has been regularly attending AA meetings. She was attending AA meetings multiple times a week when she could. She has also been doing schooling, which her time in custody has put at risk of losing her progress there. And she did turn herself in. We spoke about the bond violation, I believe, on the Friday before. She turned herself in at 7:50 a.m. on a Monday to ensure that she could get on the magistrate's docket to be arraigned on that bond violation. So she obviously taking this matter seriously. So I would ask for the consideration that she be allowed to be released today and have about a reasonable amount of time to set up an inpatient treatment program, particularly if she does have the power to do that.
Beatrice Claire on behalf of probation, Your Honor, if the court were to go that route, probation at a minimum would ask that the scram tether go on before she is released from custody. Probation would also ask that she report directly to me within 24 hours of her release. So if she were released today, I would ask that she report to my office tomorrow, and then I would work with her in getting into an inpatient program at the very least. My concern.
Go ahead.
That has been going on. There were 3, I think, different violations of the alcohol while she was on the scram tether already. So probation does have concerns that might continue if she is released.
Okay. Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening assessment identifies the benefit of inpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. Therefore, the sentence of the court, and I'm going to run any sentence for the violation concurrent with this, place you on 24 months of probation. You're to pay $855 fines and court costs, a $100 prosecution recovery cost, $100 police agency recovery costs, and $720 probation oversight fees. I'm going to order that be paid on a payment plan as directed by probation. You understand that, ma'am?
Mm-hmm. Yes, sir.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete inpatient substance abuse treatment, including all after and following all aftercare recommendations, and provide status reports to probation. You are to attend 3A meetings per week with monthly verification to probation. You are to provide proof of victims impact panel attendance to probation. You're to report to community corrections within 24 hours of release from inpatient treatment for placement on the scram tether and continue that scram tether for a period of 90 days. You're to contact probation within 24 hours of your release from either jail or inpatient treatment, and then report as directed by probation. With regard to jail time, in this case, ma'am, I'm going to tell you, Ms. Keesley, I'm concerned. All right. very concerned. Because when I put you on the scram tether, got a series of violations. Seriously?
It's my hand.
What is that? You're supposed to do something, right? I don't feel safe. Anyway, but what you did is you violated, and I get that part of it, but what my concern is particularly as I look at your families, is that there's going to come a time where this happens and we're not going to get you back. That's my worry. And I don't want to see that happen. And when I say that, although with all due respect to the rest of your family, I'm sitting here looking at your two kids, and I don't want that. Okay. So I'm not going to, because of that, what's in the violation, I'm not going to release you today, but I'm going to do something a little bit different. Okay. And that is that I'm going to order it as it's indicated here, 93 days in jail. Credit 10. She's to remain in custody until direct release to inpatient treatment. And then the balance will be suspended. That's what I'm going to order at this point. Ms. Polera, you will check with the jail to see if we can push her up on that list. Mr. Buckovich, I suggest that you get some information from your client, see whether or not we can get inpatient set up right away. I don't want her just sitting in jail, languishing. I want her out. We've got two mechanisms to do it through the jail. She's got insurance that may be able to pay for it for inpatient. The other problem is the longer we leave her in, the less likely they're going to take her into inpatient. So let's do that. And what I will do then, although it's unusual, I've got next week.
Say that again.
I have next week. I'm on the docket next week.
Yes, sir.
3rd. All right. So I'm going to set a review of the imposition of jail 1 week out on June 3rd, 2026 at what time you want me to?
It'll be at 10 a.m.
At 10 a.m. Okay, if you're out, I'm just going to cancel that hearing. I don't need to see anybody. But if you're in, then and still in, and nothing that we've done is work to push that up, then I'll look at something else to do. Fair enough.
May I ask a question, Your Honor? I
Want me to change my mind?
no.
Okay, no, go ahead.
I can't hear very good, so I don't want to walk out of here and not know.
Okay.
So I'm staying until they get me into in treatment.
Yes.
Oh, I'm sorry.
Yeah. Well, I'm looking to want you to leave here where you have those things. You've got a family that's behind you.
Mhm.
I want you to be positioned to give yourself the best chances of success. That's going to be inpatient treatment to start with. Okay. So what I've done is I ordered you to stay there. We'll use the programming that's in the jail to see if we can get you in inpatient treatment. If we can make that happen sooner, then we're going to try to do that. In the interim, your attorney also is going to be trying to work with getting you into inpatient treatment, or at least understanding how we can try to do that. You've got insurance that may be able to pay for it. So if you've got that, then we can do it. It might be also, since you've got insurance, that the jail may be able to use that to get you headed that way. Now I say that, but I'm not hopeful on that, because usually you may have the kind of insurance that won't allow it to happen that way from jail. So we might have to let you out and then you go. But either way, that's what I'm looking for. Yeah.
My family doesn't need to try and find a place.
Oh, no. I'm by no means indicating that.
Okay.
They can certainly help. And if your
Okay.
family finds something, they should contact your attorneys, let them know so that then they can follow up on that. They can do it that way. They can also contact Ms. Polera because Ms. Polera doesn't get enough phone calls. They can contact Ms. Polera and we can run it that way. Either way, any of them feel comfortable doing it to try to get you in. Okay? Then answer everything.
Yes, thank you, Your Honor.
All right, Susan, good luck to you.
you.
All right.
She has 2 cases.
Yes.
There's another case? Oh. Will you stop it? No. All right, she does.
I am, turn my life around.
No, I got you. All right, court does call the case of People versus Shannon Kiesling. That's case 25-1661. I thought this was on a different day. All right. Go ahead.
Yes, Your Honor. Assistant Public Defendant Buckovich on behalf of Ms. Keeson.
All right. Anything else you want to say?
I would just have repeated all my arguments made earlier and asked that the court adopt the recommendation.
This one also being an OUIL, the court does acknowledge this is not a serious misdemeanor as defined by statute. However, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of inpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, probation supervision is recommended, and the court will follow that recommendation of probation with the stated rehabilitative goals to prevent change, prevent recidivism, and monitor compliance with recommended treatment. So, sentence of the court: 24 months probation. You're to pay $1,255 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs. I'm going to waive the probation oversight fee since I've assessed them on the previous case. That's to be paid in the payment plan as arranged by probation. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete inpatient substance abuse treatment, including all recommended aftercare with status reports to probation. You are to attend 3 AA meetings per week with monthly verification to probation. You're to provide proof of a victim's impact panel attendance to probation. You're to report 2 community corrections within 24 hours of release from inpatient treatment to be placed on a scram tether. That tether will continue for a period of 90 days. You are to contact probation within 24 hours of any release from inpatient treatment or jail, and then report as directed. I'll order 365 days in jail, credit 10, defendant to remain in custody until direct release to inpatient treatment, and then the balance will be suspended. All right. And so that it's clear on this second sentence, I'm going to do it along the same terms as I've indicated with the other one.
Understood, Your Honor.
And Your Honor, that will also be set for review, correct?
Yes, on June 3rd. Yes. Thank you. All right. Kiesling, good luck to you. See you. You're welcome. Court does call the case of the People versus Sherry Walker. You use censor.
No, the clerk.
All right.
And Assistant Public Defendant Nick Buckovich on behalf of Ms. Walker.
Hello. Your name?
Walker.
Mr. Buckovich.
Yes, Your Honor, we are here today for a show cause. It looks like it's just fines and costs we have to pay in this case. I did work with Ms. Walker yesterday to submit a ability to pay form with the court. Obviously, we did our best to be able to do that. Currently, she is in custody on another matter, but she does have a pretrial scheduled for tomorrow. So I'm unsure exactly what may happen with her bond and that
Trial or a PCC?
pretrial, Your Honor. It's in 14B.
Okay.
So currently, she does unfortunately have no income. She did do source of income, so at this time to pay the fines and costs. And as I indicated, I did work with Ms. Walker yesterday, Phil. Go to the pay form.
What's holding her in custody right now?
Currently, it looks like he does have a at 14B scheduled for a pretrial tomorrow. I believe the bond is $15,000 with the right to post 10%, so a $1,500 bond.
Yes, ma'am.
Sir, they cut me off my SSI.
That's what I was trying to get to that, but go
Oh.
ahead. No, you can go ahead and tell me.
I paid like $60 when I first got and they cut me off, so I have no money whatsoever. They in Section 8 is paying my rent on zero rent. So
Rent through Section 8 is your portion is zero.
zero, yes, sir.
She's in on my case for a year. Right? Everything on this is fines and costs. I don't see a restitution issue.
Correct. They're $95.
May I say something, sir? May I say something else?
You want to say something else?
Um,
Ever heard that saying, when you're winning, you ought to be quiet? All right, go ahead. You got anything you want to say then? No, I didn't think so. Because by the time you get out, you're going to have to try to turn that back on. You got to find a way to get yourself out of here prior to that point in time, even to maintain your housing. But it tells me a lot, that the fact that your rent is set at zero. I'm going to waive all the fines and costs except the $125 state fee. Thank you. Have a great day.
Okay, break that down for me. I just have to pay $125.
If you want to pay it.
I really don't understand.
I know, Mr. Bukovich, you explain it. Ma'am, you're good. I just did a great thing. If I do say so myself. All right, you're welcome. Someday when you get back there and think about it, you're going to think it's great too.
Okay.
All right. Take care, Miss Walker.
We're gonna go through Dennis Walker. I'm gonna send you an attorney a message.
Yeah.
You can just grab them from her because she's like a hoarding, but yeah, you guys should fight.
We're eventually gonna run out of custodies as they're non-public, so just so you know.
What? Where's this person?
Coming.
Will be on the record in BU 2023 TR 2116, State of Kansas versus Brandon Michael Brigham. Please announce appearances.
Joseph Baca, appearing for the state of Kansas.
And Your Honor, Ray Cannell with the firm of Cannell and Cannell on behalf of Brandon Brigham, who's also here personally.
I believe this is Mr. Brigham's first appearance. No, it's not. He's had several things going on over the course of time, from failure to appear at first appearance, but then he got that squared away. And up to 26. There was no proof of insurance charge. Was that ultimately dismissed for proof?
Yeah, Judge, he was charged with speeding, which was resolved by diversion, and with failure to have a license in possession, which was resolved with presentation of the license. So those two charges were resolved. The reason we're here today is, unfortunately, he was not made aware that you had a hearing on those two charges set for September 20th, 2023. If you look at the court record, it will reflect that no service or of notice was provided to Mr. Brigham. And unfortunately, at that hearing, because he didn't appear, you issued a bench warrant. Unfortunately, it was an error because he didn't have any notice. He didn't knowingly fail to appear. And that wasn't discovered until February of 2025, when he was stopped and an officer in Wichita noted that there was an outstanding bench warrant for his arrest. He was arrested, taken to jail, and had to bond out. At that point, Judge, I entered my appearance in March of 2025, and I filed a motion with the court in September of 2025 to quash the bench warrant and cited the statutory grounds because he didn't knowingly fail to appear. And that was asked to be set for hearing. It was not. After that entry of appearance and motion to quash, the prosecutor filed a dismissal of the case. We're here today, Judge, to ask the court respectfully. Mr. Branham's never been in court before. He's never been arrested before. We'd like to get that record back to what it was before September of 2023. We'd ask the court, after we present the record, that you quash the bench warrant because it wasn't issued correctly, and that any record of that bench warrant be expunged. We also have a request that the arrest that occurred based on the bench warrant that had no probable cause be expunged. And then his record will be as it was before September of 2023. That's our position, Judge. We have exhibits to support that position.
Well, this case has been dismissed. Is that right?
That's correct. That's correct, Judge, but it was dismissed on the prosecutor's request without any notice to me, without any approval from me. And the statute is pretty clear that if I've entered my appearance, that he's required under KSA 6240 to get my signature on the dismissal, which was not done. So I don't believe it was a valid dismissal, Your Honor.
All right. Well, it started out as speeding 80 and a 65 and driving without proof of insurance on March 17th of the year 2023. Let me see. It looks like it was dismissed after diversion, May 27 of 26. I see March 18th of 26 notice of hearing. And there was a bond release December 20th, 25. I'm going backwards. Let me start at the beginning. Okay. Probable cause arrest report affidavit was filed June 20th of 23 with the information charging him. A summons was issued the same date. And then the next activity in the file, that was June 20th of 23. Return of service unserved summons, August 18th of 23.
If you look at that return, Judge, it will reflect that no service was obtained.
Okay. This is a gated neighborhood, need code to open gates. They couldn't get in. And because we couldn't get service on him, a state's warrant was issued, I believe. Let me see what that next warrant looks like. Summons unserved, so a bench warrant did issue because there was no other way to get him in here. That would have been his notice. And bond was fixed at 1,000 cash for surety. Is that the warrant you're complaining about, Mr. Cannell?
Yes, Judge. I mean, the facts would be that the officer could have gotten in. He just pushes 0 and asks for entry. But regardless, under 215915, the Kansas statute, he should not have been found guilty of failure to appear because he didn't knowingly fail to appear. There wasn't any notice.
Well, I don't know that it was because he knowingly failed to appear as it was. There just wasn't any other way to get notice to him. The state could have issued a warrant instead of a summons from the get-go. But I probably need to study the case a little more before I start relying on any facts of that sort.
I think you'll find, Judge, that he works. He could have been served by mail. There were several ways that they could have gotten service to him, and they did not.
Okay, so then so is this what remedy are you seeking, Mr. Cannell?
I'm seeking to quash the bench warrant and to have that bench warrant expunged so that when he has to fill out forms, he can state that he's never been guilty of failure to appear or in violation of a bench warrant. I'm also seeking an expungement of the arrest that occurred based on that bench warrant because it wasn't based on probable cause. Should not have been issued, and so the arrest should not have occurred. But he needs to clear his record, Judge, and that's what we're attempting to do.
But you have not filed a motion for expungement?
I have a motion right here for expungement, Judge, that I intended to provide the court as well as the prosecutor.
Well, I'm certainly going to need some time to review this. I don't know if the prosecutor, if you've had time to review this. But is it it's not a motion to expunge at this time. It's a motion to quash the warrant in a case that's already closed. But you're saying that it shouldn't have been closed because you would have objected to it being closed?
I do. I don't think he had a legal right to dismiss it, Judge, without my notice and signature. And I think the statute clearly states.
Didn't he act in response to a diversion, though? Does that make any difference in your position?
Not in my research, Judge.
All right, well, I'm going to.
Plus the issue, Judge, is I had a motion before the court to quash the bench warrant. That was in September, and the dismissal didn't occur till after that. So
I see.
That should not have occurred without us having an opportunity for a hearing.
Well, we will have an opportunity for hearing. Let's set this, Mr. Baca, do you think on 1:30, if we have time anywhere in the near future to set it for argument? Because I don't think we're going to resolve this today.
Judge, I think we can, although I'm not sure any of this really needs to be heard. If he's asking for a warrant to quash that's already been done, executed, and resolved, it seems moot at this point. And so if the court finds that because the warrant has already been satisfied, it's not a current warrant that is outstanding and he's wanting to quash it. It's been done and completed. And so if his second point, and this is my best interpretation from what he's filed as far as the relief he's asking for, the second point seems to me he's asking to expunge the arrest. It's not a proper petition for expungement under 2166-14, but if the court is still taking that up, he needs to file that petition properly. And even so, he might want to read that statute because it's very clear that 3 years have to elapse since the resolution of the case to be considered. Now, this dismissal was done in October of 25. And so if his second point is he's asking for an expungement of that arrest, even if he wants to file that petition, which he can, I don't think enough time has elapsed to consider that. And then finally, although I don't know and see him asking for this in the letter he's filed, but as far as the dismissal, this was a diversion agreement. And it's a diversion agreement that Mr. Cannell signed. And on page 2 of that diversion agreement, it does state that once that completed, a dismissal will be filed. So I'm not sure about his complaint and what relief he really wants about not signing the dismissal, but those were the terms of the diversion that he agreed and signed to. So we can set a date. I do think he needs to figure out exactly what he's asking for. And if it is a petition to expunge that arrest record, he needs to file that as a proper petition. And again, I would encourage him to read the statute because I believe 3 years need to elapse before he can ask for relief on expunging that arrest.
Well, that is my recollection of the expungement statute, and maybe that's why he hasn't pursued expungement because the time hasn't lapsed.
Yeah, my position, Judge, is that
yes,
a condition precedent to filing that would be that the court enter a decision to quash the bench warrant because it wasn't properly issued and expunge that, and then I have a basis for filing the petition to expunge the arrest. But until you made a ruling on the bench warrant, I don't, in my opinion. So I brought a petition for expungement, but it was dependent upon the court making a decision today that he didn't have knowledge and notice of the hearing, so there wasn't probable cause for the bench warrant.
So this case was just dismissed. It says May 27, that's today.
Your Honor, my copy of the dismissal was filed October 29th of 2025.
Oh, I'm seeing the clerk's note about today's hearing that the case is dismissed. She's alerting me that it's dismissed already. Well, Mr. Cannell, I don't think I have any authority over this case now that it's dismissed. I don't think, say it's dismissed, I don't think that I have any jurisdiction to go back in and open it up at this point, except if we do, I'd have to review the expungement statute. But in reviewing the file, it looks like that warrant would have been, to just first glance at the docket notes, it looks like that warrant was appropriate. But I'm not going to rule on that because I just don't think I have authority to make rulings right now on this. Other than what
Well, I think you do. I think you do, Your Honor.
Excuse me,
Under
go ahead.
KSA 6240, the
Well, I'll review
dismissal,
that.
KSA
Okay.
6240, the dismissal should have required my approval, and I had filed a motion with the court and asked for a hearing prior to that dismissal being entered and didn't have an opportunity for that hearing. And I
All
think
right.
that, okay,
I will take all of this under advisement and set this over for rehearing if necessary. When's my next available date, Jenna?
You want to do it on a Wednesday afternoon?
If we have one anywhere in the near future, that'd be fine. That's usually when I put these kind of
I have July 8th.
July 8th. That's probably the earliest you can get me back in with these gentlemen. July 8th at 1:30. Are you, counsel, are
do
you
you have,
available?
I'm sorry, Your Honor, but do you have any time on June the 17th, Wednesday afternoon?
Okay, how about that? June the 17th? Can you squeeze us in there?
Let me look.
Thank you.
That's designated traffic trial dockets, but if I have evidence, I try to squeeze them in there if there's the potential or if they're going to take longer than what this docket this morning holds, allows.
Yes, Your Honor, I can do it.
Thank
All
you.
right.
Thank you.
I'm going
Okay.
to continue this over to June 17th at 1:30. And I'm not going to order briefs, but if anybody wants to submit them, you can. Just make sure I get them timely so that I can read and consider and study. And of
All
course,
right.
if you do that, opposing counsel will need copies of that too in a timely fashion. But I'm not ordering it. It's up to you.
All right. Thank you, Judge.
Mr. Bacher, are you okay with all of that? Anything you want to say?
I'll just say, Judge, is the court just going to be going on Mr. Cannell's, what I'm guessing is a motion? It seemed more of like a mail correspondence letter, or is the court wanting him to file something a bit more formal? It's very difficult to understand exactly what statutes, authority, and relief in all of that he's even asking for in what he's currently filed. If we want to proceed on that, I understand. I'm just a bit confused based on how it's filed.
Yeah, here's the situation I see, Mr. Baca. He filed it. I'm going to study it. If I can make sense of it and make a ruling at the next hearing, I will do that. If I can't, I can't. So it's on him how he wants to present that. Maybe he
Thank you,
thinks
Judge.
that it is. Maybe he thinks it's fine, and maybe it is. I don't know. But that's about the best I can tell you right now.
Yes,
I
sir.
just-
Thank you.
I just don't even know that I have authority to rule on anything. And so I'm kind of going out here maybe without authority right now with what I've said so far. But that's what I'm going to find out.
All right. Well, I think
Thank
you
you,
do,
gentlemen.
Judge. So we appreciate the accommodation and the hearing this morning. Thank you.
All right, you're welcome. You may go, Mr. Cannell and Mr. Brigham.
Thank you.
You're welcome. We are on the record in BU 2025 TR 2872 State of Kansas versus Tyrell Wynn Kane. County Attorney Jared Regier for the state. Mr. Kane appears in person. And pro se, you are Tyrell Kane?
Yes. Yes, ma'am.
Okay. You were here March 18th of 2026 and waived your right to attorney. And we're going to provide proof of window tint removal to the county attorney. Are you still wanting to proceed without an attorney?
Yes, ma'am.
I'll have the record reflect that you're still proceeding on your waiver. Now, what did you do about this one-way glass or excessive tint? Did you get rid of that?
Yes, ma'am. I did.
Did you get any proof to the county attorney that you did that?
Yesterday I went to the El Dorado Police Department and an officer tested it for me and said he was going to send an email.
Okay. Mr. Regier, do you know if you got that email in your file?
Your Honor, notwithstanding the close proximity, especially in light of the 2 months prior to the previous hearing, my office has received some updated information regarding this matter. Additionally, at this time, the state would make an oral motion to dismiss count 2 of the amended information, improper sunscreen device, a class C non-person misdemeanor. The state makes no motions insofar as count 1 is concerned and is prepared to proceed on that matter.
All right, so on January 8th, no driver's license in possession was dismissed in count 3 in an amended information. Now count 2 is being dismissed, but that leaves count 1 speeding 84 and a 55, Mr. Regier.
That would be the state's information if the court is prepared to rule on the state's oral motion.
The state will grant the oral motion. So that leaves you, Mr. Kane, to tell me how you want to continue to plead on count 1, speeding, the only remaining charge. Speeding 84 is 55. Do you want to plead, continue not guilty and set this for trial? Do you want to plead guilty and proceed with sentencing? Do you want to plead no contest, neither admitting or denying, but still being found guilty and proceeding to sentencing? Or do you want to look into diversion, or have you done that?
No contest, Your Honor.
By pleading no contest, again, you're not admitting it, but you don't want to deny it and take it to trial?
Yes, ma'am.
You understand you'll still be found guilty?
Yes, ma'am.
Is anyone making you give up your right to trial and enter this plea of guilty today?
No, ma'am.
Very well, I will find that you know what you're doing. You're doing it voluntarily. And so you're pleading, you said no contest?
Yes, ma'am.
Mr. Regier, does the state have a factual basis to support this?
One moment, Your Honor, I'm confirming one final matter.
Very well.
Yes, Your Honor. And before I proceed on that front, for the court's edification, the state does wish to address disposition at the appropriate time in the event the court does accept the no contest plea. Insofar as the no contest plea is concerned, the state's evidence would show where this case proceeded to trial, that a stop occurred on December 24th, 2025 at the intersection of Butler Road and Northeast 30th Street. State's information is that is within Butler County boundaries, specifically between Whitewater and Benton city limits. The stop, as indicated on the ticket, involves a 2011 Chevrolet Tahoe, and the state's evidence would show the same where this case proceeded to trial, and that the defendant was determined to be the driver of such motor vehicle. Additionally, besides citing the defendant for a violation of KSA 8-1558, the officer determined that the defendant was driving at an alleged speed of 84 miles per hour using stalker radar, where the legal speed was 55 miles per hour. And again, the state's evidence would show the same were this case to proceed to trial.
Not only does the court find the defendant has knowingly and voluntarily entered a no contest plea, or not only does the court find that the defendant has knowingly and voluntarily entered a no contest plea, the court also finds the state has provided an adequate factual basis to support the count and the plea. So I do find the defendant guilty as charged, speeding 84 and a 55. Mr. Regier, I think there's a 10 or 186 scheduled fine on that.
That is the state's understanding, Your Honor, although the state does respectfully submit that pursuant to KSA 82118 subsection C, that does not limit the court's find insofar as a prospective sentence is concerned. In this particular matter, the state is recommending an elevated fine of $300. The state does not do so lightly. However, the state's information is that this is defendant who was previously convicted approximately 1 month and a half prior to the alleged occurrence date of the same offense. If the court will accept a proffer from the certified driving record, it would appear the defendant was convicted of speeding by Andover Municipal Court on November 14th of 2025 with an alleged occurrence date of September 28, 2025. And the ticket in this case refers to a stop on December 24th of 2025, all within approximately 3 months of each other. Under those circumstances, the state does respond as appropriate.
Now, that roadway you described a while ago, is that a 2-lane county highway?
That would appear accurate, Your Honor, both based off of the ticket and the statutory provisions of KSA 8-1558, specifically subsection A3.
And do you have the speed he was going in the prior ticket?
Unfortunately, Your Honor, I do not have that information directly in front of me.
All right. So, Mr. Kane, Christmas Eve last year, 2025, what was motivating you to speed 84 in this 55 mile per hour zone?
I don't remember.
Okay. Well, doesn't sound like there's anything important, huh? Not
Your Honor, if I may interject very briefly.
Go ahead. I think I know what you're going to say. Go ahead.
Yes, Your Honor. While I cannot speak as to anything else beyond the date of the stop, I have had the opportunity to review the certified driving record in full. It does appear that the prior conviction involved an actual speed of 32 miles per hour, where the posted speed limit was 20 miles per hour, 12 over, which would appear to be somewhat less than the 29 miles per hour speed before in excess per the ticket in this matter.
32 and a 20, for it to be marked 20 tells me something, and 32 and a 20, that's pretty excessive anyway. All right, well, I thought, Mr. Kane, what the prosecutor was going to say is it doesn't matter what your reasoning was, you were still speeding, and that would have been true. But those speeds are set in large part as safety measures. How old are you, sir?
I'm 17.
You're 17. Are you in high school?
Yes, ma'am.
What grade?
I'll be a senior next year.
Okay, so you just finished your junior year?
Yes, ma'am.
Do you drive to school?
Yes, ma'am.
You have a job?
Yes, ma'am.
Where do you work?
Diamond Creek Transport in Newton.
How far of a drive is that from your house? How long does it take?
25 minutes.
How long have you worked at that company?
For 3 years.
Is that a family business?
Yes, ma'am.
Okay. Do you have parents,
Yes, ma'am.
mom and dad?
Yes, ma'am.
What action, if any, did they take over these speeding tickets?
I got in trouble and grounded.
What's that mean, grounded? That means a lot of different things.
Like I could not go anywhere or do anything really. I was stuck at home.
For how long?
A month.
Did they talk to you about the consequences on insurance and the dangers and all of that?
Insurance and danger. Yes, ma'am. I did.
Have these 2 tickets affected your insurance any yet?
I'm not sure.
You don't pay your own insurance?
No.
Mom and dad do?
Yes, ma'am.
Well, Mr. Kane, are you related to Trooper Kane?
I do not think so.
He spells it the same way. All right. Well, you are awfully young to be injured or killed in a car wreck. You're awfully young to go to prison for killing someone else in a car wreck. But at 17, you could be tried as an adult under certain circumstances, and you could go to prison with the hardened prisoners. And this was a truck you were driving?
A Tahoe.
Oh, so that's kind of like a sport utility, or was it a truck?
It's kind of like a Suburban, I guess.
Oh,
Like
okay. That's what I thought. Okay. Um, hmm. Well, on one hand, this may seem like, oh, it's just a speeding ticket. Why make such a big deal? Because you're young, you're not the most experienced at your age. Driving is an adult activity that is just dangerous in and of itself. And I kind of want to nip this in the bud. I don't want you to keep repeating this now that you've had 2 already in such close proximity, but maybe you haven't had any in the last 5 months, which is good. I'm going to follow the state's recommendation and enhance that fine. It was going to be 186, but because I want to make this impression on you not to do this again, not to endanger yourself or others, $300 fine, 108 court costs, so the total is 408. I will give you time to pay that. How much time do you need to pay that, sir?
If I could, I'd just like to pay today.
You've got the money in your pocket to pay it today?
Yes, ma'am.
Well, it doesn't sound like it's going to make much of an impression on you if you can just go pay it today and forget about it.
Would you recommend me wait?
No, pay it today. Pay it today. But I hope you think about why you shouldn't be driving like this.
Yes, ma'am. I already know. I've been thinking about it for the last couple of months because I've been waiting.
Okay. And don't be putting that dark sunscreen back on your vehicle again. So, all right, you may go, sir.
Thank you,
At
ma'am.
the clerk's office, you're welcome.
Where did I pay this?
That's the whole last door on the right.
And tell them the total is $294. They'll put that in their unapplied account, $294. Tell them $294. Officer, did you give that to him? Yes.
294, I thought you said 300.
I did. $294 was what it was going to be. It's 408.
Thank you, Your Honor.
Yeah. Yeah. I wrote the cost of the original ticket, the 108. It's 408. Tell them 408, not 294.
Yes, Your Honor.
All right. Thank you, Mr. McGeer and officer. We're on the record in 2020 TR 768, State of Kansas versus Donna Jean Hartgraves. Joseph Baca for the state, and Donna Jean Hartgraves appears in person, and pro se. Ms. Hartgraves, Darren Patterson had been appointed to your case, but then you failed to appear at one point. He was here.
I had the flu and I had to call in. I didn't want to get everybody sick. But I'm here today and I'm ready to get this over with.
Well, you're not going to get it over with without your attorney. Did you contact your attorney and tell him you had court today?
I called him last week. He told me to be here at 9 o'clock. He knew I had court.
Okay, well, you're on a $6,000 bond with AAA Butler County that you posted 2/11 of 25, but that's the one, no, that's the one that you're on now. No, it's not. Actually, when she failed to appear March 16th, a bench warrant was issued and bond was raised to 12,000 OR. Deputy, do you show that warrant still outstanding? I think it might be.
Oh,
You still have it outstanding, don't you? That failure to appear warrant from March 16th?
I'll have to call control and have them check real quick.
Okay. Well, you've had a lot of hearings so far, and we haven't gotten where we need to be to wrap it up. Let's see. The county attorney, February 11 of 2021, the county attorney granted diversion and gave her from February 11 to 7/22 to come up with money due.
On Hartgraves, achievement award, 20 PR 768.
She ended up having a hearing set August 15th of 22. Darren Patterson was present, but she failed to appear. So a motion to revoke diversion was granted August 15th of 22. She didn't get they gave her from February to July to pay the diversion acceptance fee, and she didn't. So the county attorney filed a motion and it was revoked. Darren Patterson present, but not the defendant. Then October 3rd of 22, the defendant was supposed to be back for the trial on stipulated facts. She failed to appear. Mr. Patterson was present. Bench warrant issued 6,000 cash or surety, and she did make that bond. January 7th, 25, 3 years later, there's a note that the defendant had paid the balance through collections and had gotten her driver's license reinstated. And then the next docket note, January 14th, 25, defendant called in stating that someone said they would send her a receipt showing she paid the case. Clerk said that's not something we do on a diversion. Maybe you talk to Butler and Associates, the folks that do the collections. She was going to call Butler and Associates back. And then May 29th, an email was sent to the county attorney's office from the clerk requesting clarification if the case needed to remain on the docket, as defendant had paid the case and had her license allegedly reinstated since December 23. And as of January of 25, they were asking if the warrant needed to be recalled. And I'm not sure what the state's position is on this, other than the defendant's warrant was received in February. I don't know what that means. Oh, and then there's a whole bunch more. I don't know that we need to read through all of these. Okay, so then August 11th of 25, we got her in here, at least by Zoom, from a separate location as her attorney. We had the trial on stipulated facts. She stipulated it was set over for sentencing. So she stipulated, we had a trial on stipulated facts, August 11, 25. She was found guilty, but we had to set it over for sentencing to October 27th of 25 with the order that she get the mandatory drug and alcohol evaluation. Then on that date, October 27th of 25, Attorney Patterson was present, and he asked that we set this over at the defendant's request, which we did. That must have been when you were sick, to December 29th. December 29th, Mr. Patterson was present. It was set over again. Maybe that was when you were sick. That's what he said, asked that we set it over again to March 16th. Now we set it over there because it looks like you didn't get the alcohol and drug evaluation as ordered months before. So we set it over again at the defendant's request. Then on March 16th of this year, 2026, Mr. Patterson was present, but the defendant failed to appear. And that's when the bench warrant, a new bench warrant was issued and the bond went up to 1,200 OR. And here we are today, and it doesn't look like she has probably surrendered on that bond or been arrested, because it looks to me like that 1,200 OR is still outstanding. Anyone
Your
have
Honor,
anything to say? Yes,
according to the jail, there's no active warrants.
Done everything.
Well, are they showing she posted a $1,200 bond?
Judge, I have a copy of a bond for 12,000 OR that has an appearance date for today. Looks like it was executed March 19th.
Okay, so that's why there's not an active warrant. She has been arrested on that. Because there was a bench warrant March 17th, and you said March 19th is the bond?
Yes, Your Honor, that's the date I have on the copy I'm looking at.
Well, that's kind of the problem we had on that first case on the docket this morning. The defendant allegedly tried to surrender, but couldn't because the jail said there wasn't an active warrant. So there must be some glitch between issuing the warrant in the official file to catching up with the jail. And if we see any more of those, we may have to kind of try to track down if there is a glitch and what it is.
And
But
Your
in
Honor,
this case, go ahead,
I
Jenna.
can reach out to the jail and see if they have a return and it just hasn't been filed to us yet.
That could be what it is. Yeah. That would
Because if she
explain
has
this
a
case.
bond, usually it comes, we get return and then the bond.
Mm-hmm.
So I can check into that as well.
Yeah, that sounds like in this case might just be the issue. I'm looking. Because I see March 17th bench warrant issued. And then that's the last activity in the file. But you said March 19th, Mr. Baca, there was a warrant signed.
That's the date on the warrant or on the bond.
On the bond. Okay, so we just need to get yeah, Jen, if you want to just talk with the jail and see what the return is on that. Okay, so let's proceed. We need to get this put on a Monday docket, so not only Mr. Patterson, but the defendant will hopefully be here. Ms. Hargrove, you're going to have to be diligent about getting to court.
I will. I've only missed once because I was sick.
No, you've missed more than that because I was going through the history. Mr. Patterson was here for a lot of hearings that you weren't. So
Well, I've been here every time but once, I thought. I'm sorry.
Okay, well, I will tell you, if this continues to be the pattern, I may just have to order, if I have to order another warrant, you may just have to stay in jail without bond until we get this resolved. And I would hate to do that. I know no one would want to see it. Well, you don't have to freak out as long as you're here. So let's continue this, Jenna, to a Monday with Mr. Patterson.
We'll put that August 17th.
All right, August 17th at 9 a.m. And I'm going to, I'll continue that bond that apparently exists with the added condition that you reappear August 17th at 9 a.m. But I'm also ordering that you walk across the street today to Mr. Patterson's office. It's right across in the parking lot, as you may know.
Okay.
And you give his staff any information they can to contact you so you guys can be in touch and we can get this resolved. This is a 2020 case.
I know.
So I think that tells you you've missed more than once. All right. So if you don't miss any more court, you'll be okay. But if you miss again, you won't be so okay.
Okay. Thank you.
Right.
Thank you,
You're
Judge.
welcome. Mr. Baca, anything further before we let her go?
Judge, I do want to maybe nip something in the bud before it's a problem later. I think the latest drug and alcohol evaluation that we need for sentencing was done in March. Are you going to want her to have a new one completed before that August sentencing date?
Well, March of 26, she had one.
I believe that's the most recent one that we received a copy from Attorney Patterson, and that's the most recent copy we have.
That should be sufficient. The reason I had to order it after the trial and stipulated facts is because so many years I think had passed since she had it done for the diversion.
Okay.
But if it's just a few months old, well, it's not just a few months, it's getting more. Let's see, that's from March to July to August. I see what you're saying. Are you in any kind of treatment right now, Miss Hargraves?
No, I've done all my treatment. I've paid for all my classes. I thought everything was done, actually.
Mr. Baca, is there anything in that report that makes you think maybe she needs a new one? Because otherwise, if she gets in here and I look at it in August and I may want an update, I don't know.
Judge, I know they may not have all the information. I'm not aware of anything that is causing a concern for the state of why that one cannot be used at this time, but I would understand the court's concern on the time as well.
All right, well, if you and Mr. Patterson can just kind of touch base about that, the two of you can kind of figure out if maybe we need if you think we need an updated one, let's get it done before the hearing. Because I
Yes,
hate
Your
to have
Honor.
to continue it again, as old as it is. All right, Ms. Hargraves, I'm gonna let you go on that bond, but you get over there to Mr. Patterson's and
Okay,
get
I will.
information.
I
And then
will,
be
Judge.
sure and
Thank you.
be back here August 17th, 9 a.m.
All right, I will be. It says
Okay.
8 on my deal here. Is
Well,
it 8 or
8 o'clock.
9?
It's 8. Mr. Patterson wants
8.
you to be here at 8, so I'm gonna say 8. I thought about
Okay,
that.
all righty.
Okay, you may go. All right.
Yeah. Now running with Bronson Williams the third, actually.
You said that's for page one?
Yeah, it's been my, I don't know, I'm not sure what's. But either way, I'm here and Kyle knows that I'm on it because she's talking to me about it. So.
Yeah, I have a note from April 1st.
Yeah.
We're on it.
In 25 CR 1839, Mr. Williams, you probably are intimately familiar. This isn't good. So I always look ahead to see how this ends, how the story ends, and it's not good. You are punished in America criminally in two phases: the circumstances of the crime and criminal history. Those are the two parts that make up the punishment. You are charged here in this indictment with the third-degree felony of unlawful possession of a firearm by a previous convicted felon. So we know you have a previous conviction, at least according to this indictment. Then paragraph 2 goes on to state that you were convicted out of Jefferson Parish, Louisiana in 2012 for use of a firearm, and it says CBS, I don't know what that means, or crime of violence. Then paragraph 3 of the indictment states, in November 7th of 2013, out of Jefferson Parish, you were convicted of illegal possession of heroin, cocaine, and a felon in possession of a weapon, which you're charged with now, which should never happen again. Paragraph 4 goes on to allege that after the conviction of firearm use or crime of violence in 2012 out of Jefferson Parish, Louisiana, became final, and after the conviction of illegal possession of heroin, cocaine, and convicted felon with a weapon in 2013 out of Jefferson Parish. After those convictions were final, it is alleged you committed the felony of introducing contraband into or upon the grounds of any state correctional institution, and you were finally convicted of that. Bringing contraband into a prison, I guess. You were convicted of that out of Franklin Parish, Louisiana in 2018. And finally, the final paragraph of the indictment goes on to state that after the conviction in clause number 3244, which is again those firearm and possession convictions in 2012, and after the conviction of illegal possession of heroin, cocaine, and being a convicted felon with a weapon in 2013, all out of Jefferson Parish, Louisiana, became final. You committed the felony of introducing contraband and were convicted of that felony in 2018. And I guess that's what I don't understand why that's in there. Nonetheless, that last paragraph seems confusing, but on balance, this means because of your rich criminal history, you are looking at a minimum of 25 years in prison to life imprisonment. A minimum of 25 years in prison, up to life in prison. You understand? What's his bond on this? This is egregious. And then right now, another illegal possession of a firearm. Not on my watch.
$100,000.
That is revoked. That's not sufficient under this. Under all of these convictions, and it's still firearms use, it's not fair and right. I'm increasing it to $200,000.
Your Honor, I would argue.
You
that
can argue, go ahead and make your statement.
He's been in court every single time. He's never missed court. He's always been here. That's one of the main reasons for bond, is to make sure.
It's one of the main reasons.
Well, I said one of the main reasons. This is, if you look at his prior history, it's
just look at.
Oh no, but it's nothing recent. It's cases that are old.
I'm sorry, he just got indicted. He just got indicted. That's recent. He just got indicted here on this case.
No, I'm saying his prior history.
I don't care. He should never ever commit a crime, much less repeat it. And I'm sorry, that's just, and it's firearms usage. Another firearms
using a firearm or not.
He's illegal possession of firearms by a felon.
Wasn't using it. It's found in the car when he was driving.
Yeah.
Well, I'm not saying it's illegal, but it's not the same thing as brandishing a firearm or using a firearm. I just want to make sure.
Paragraph 2, conviction in 2012, illegal use of a firearm.
But like you said, 2012.
I'm not through. Hold on. In 2013, convicted felon in possession of a firearm, what he just got indicted for in here. He was convicted. This is the third. 2 convictions so far, and then now a third charge of illegally using a firearm. Let's see, what else? But you were, he was a habitual felon. Let's see. 2 convictions ago. He was a habitual felon, 2 convictions prior.
Well, Your
And
Honor,
after being a convicted felon, after being a habitual felon, he was convicted of 2 crimes and now a third one.
Your Honor, I think, I don't know the rules in Louisiana. I'm not sure about their third.
Habitual felons is, I'm just looking at the habitual felon rules here for
Oh, yes,
Texas
yes, I'm saying.
and why we treat it the way it is.
Right.
But the point is, he had been treated tantamount as an habitual felon here in Texas, 2 convictions, felony convictions ago. And now he's charged with a firearm. Yes, this is most serious. This is one of the more serious cases I've dealt with recent. Shame on you. You can't learn your lesson. You've been in prison several times, and firearms have been the key on several of these, and you're still misusing it. Now, I know you made messes in Louisiana, but now I say welcome to Texas, but don't come here and mess it up. And here you are, bringing your mess into this state. Shame on you.
Your Honor, if I were to request maybe some stricter bond conditions, but leaving he's working and
How do we keep him from possessing a firearm?
well, if he possesses a firearm in the meantime, that's
You mean
another offense.
again?
Yeah, I mean,
This
that's
is his third charge. He's been convicted twice of this. Now it's a third one.
obviously.
There's nothing we can do. There's nothing we can really do to stop him from misusing firearms. He makes a mess wherever he goes. And now it's in Texas. Say welcome to Texas, but don't make messes. But no, whoever set the bond, I just articulated more than enough reason that his bond was insufficient.
And the other argument I make, Your Honor, his bond was set quite a while ago. He's been coming forward. This is not his first time appearance. We've made appearances.
This is this court.
Well, we've been in front of this facility already and reset it.
This court, and always, show me a statute that says I can't do what's in the best interest of the safety of this community.
I'm not saying you can't do it, Your Honor. I'm just asking
He's
you
a
not to
dangerous.
this time.
He has a prolific liking toward illegal use of firearms. And that's irresponsible. It's dangerous. And now he's here and he's in front of us after Louisiana finally put him into Texas. Now here we are. And now we're dealing with, he's an habitual, he's looking at 25 to life now.
Well, another range, Your Honor.
Yeah, yes, 25. How much is that worth in a bond? You think $100,000 is too much for 25 to life? I don't think so.
Well, that's what it is right now.
Not when he was looking at habitual felon status, 2 convictions previously ago.
And I think you made my argument right there, Your Honor. If this was a $20,000 bond, I would agree $20,000 is sufficient, but $100,000 is sufficient for something like this. And that's what he's on right now.
The court finds otherwise.
I mean, he's on a very high bar.
No, your representation, vigorous representation is noted, which is good. But still, it's hard for you to create facts that don't exist. And the facts speak loudly. He is irresponsible with firearms. And now he's in Texas after numerous convictions, felony convictions in Louisiana. Now he's bringing his mess into Texas, and we're going to deal with it. And each time it gets more severe. Well, that's what I'm articulating the grounds for my decision. And that's the court's decision.
We can get it on a quick docket, relative to them, see if we get it resolved.
You can put in 2 weeks. Is that good?
Yes, please.
Okay, I'll review it in 2 weeks. See what y'all might be able to do.
Talk across your radar.
But the one thing is, sir, you can't even get near a firearm.
I'm not near.
Sir, you got indicted for possession of it. Come on. Again, and another with your convictions of firearm misuse before. This is the problem.
Those were all ran concurrent. That was one concurrent.
Yeah, concurrent. They were different crimes. I don't care how they will do it over there in Louisiana. They can, but over here, each crime has its own criminal responsibility and punishment. And if they want to package it as a package deal, they can do that. But that's not the way we do things in Texas. You are held accountable for each crime. You don't get to say, well, I'll do 5 of them and I'll do it 5 for the price of 1. That's not the way it works, sir. That's like a criminal thought. And that's not the way criminals should think. And that's why criminals get in problems. Okay.
I haven't been in any trouble.
Sir, you're in trouble now. For illegal possession of a firearm. You're looking at 25 to life. You don't think that's trouble?
Yes, it is.
All right. All right. We'll deal with that responsibly. Who's a good lawyer? See if y'all can figure something out. Thank you. Why? Why was he hit?
I'm assuming he has a case over there, but according to the bailiff of misdemeanor court, he was there all morning. So I don't,
Who is that? Who is that?
That's Nathaniel Clark.
Nathaniel Clark. Where's Nathaniel Clark?
It's Mr. West.
yeah.
Come on up.
It's this morning.
Yes. Your Honor, I did confirm that he was down.
Oh, yeah.
For 3.
Why?
I don't know why, but he was mistaken. I've talked with the bailiff and he confirmed.
What are you doing there? You might as well have been on Mars.
Yes, I did.
Well, what are you doing in misdemeanor? This is a more important, serious matter. And your bond got revoked because you weren't here, but everybody is responsible to knowing where the most important thing in their life is meeting, and that's where a felony offense. That's a very important thing. If you're sitting in misdemeanor court, that's not my fault. That's your fault. I'm sorry. You have to know better. Right?
Yes, sir.
I don't care. You should have been here. I mean, and you're on bond, right?
Yes.
You have a bondsman? Yeah. Well, they told you where to go.
Yes, sir.
They direct you, pay them. You have a lawyer, he knows where it is. He was here all morning. So
Yes, sir.
sorry, sit over there.
Yes, sir. Well, I have.
Sit over there.
There's grass.
We'll deal with it at the end of all of this.
Just let him go.
Everybody, yeah.
Unless you want to find.
I don't think we'll get anything blown out today on that one. It's he would like to, he liked to chase out Mr. Burbank. He said he's been talking about the deal. So if he has your time, then maybe you can hire Mr. Burbank, thank you for all this case or try to do whatever you need.
Who is it?
It's Mr. It's from this morning.
Didn't we revoke his bond?
He wasn't trying to do that.
Yeah, he was in the wrong court.
Yeah. he was
What did you do in misdemeanor court today? Did you just sit there?
He called me in that, yeah.
Who's?
Met the Burbank. He was sitting over some permit.
Judge, this gentleman had a $10,000 bond on a habitual DWI. Your comments this morning was that you were gonna erase his bond regardless of whether or not it showed.
Doing a bunch of kilos. I was out.
I need those final. Again, the defendant's name is
Nathaniel Clark.
I think you have it next to you.
Nathaniel.
Probably one of the ones you got tomorrow. Maybe.
Probably the center one.
Okay, Mr. Clark, come on out.
Really, Harold.
Okay. There was a bond forfeiture this morning. You were in another court, so I'm going to recall the bond forfeiture. The current bond, though, is $10,000, I believe.
Correct.
That's, yes, right.
Which is woefully inadequate for a person who is charged with a felony DWI in paragraphs 1 and 2. Then we have a conviction in 1997 in the indictment out of the 4th Judicial District Court of Wichita Parish, Louisiana. After that was final, according to paragraph 1 2, 3, and 4. And again, the defendant, Nathaniel Clark, that's you. And you're here with Mr. West, your attorney and the state's attorney. But I'm reading through this indictment that was handed up in November of last year, a few months ago, by the grand jury. After that 97 felony conviction was final, it is alleged in paragraph 4 of the indictment that you committed the offense of aggravated battery, and you were finally convicted of that on May 4th, 1999, out of Wichita Parish, Louisiana. So paragraphs 1 and 2 constitute a third-degree felony. Paragraph 1, committing the offense of operating a motor vehicle while intoxicated. But paragraphs 2 go on to allege that in 2012 and 2015, you were convicted out of Wichita Parish, Louisiana, of driving while intoxicated, operating motor vehicles while intoxicated. Those two priors and this new case together are a felony in the state of Texas because of two prior DWI convictions. And this constitutes a third-degree felony, which carries with it up to 10 years in prison if convicted. But paragraphs 3 and 4, alleging the convictions in 1997 and 1999, are in sequence. This makes this a habitual felon status, which means if convicted of this, you were facing a minimum of 25 years in prison to life. A minimum 25 to life.
Thinks he might come up today.
And the bond of what was it, $10,000?
Yes, sir.
Woefully inadequate on a habitual felon status. Your bond is increased to $100,000 because of the serious nature of these allegations. If you post a bond, you must have a GPS device and you must remain in home confinement, and you can only leave your home for purposes of going to your doctor, going to your lawyer, going to get food, and those are to and from the most direct routes possible.
Your Honor, he also has a job, he works, as you see from the uniform, he works for the city of Belmont. So he does.
Yeah, and going to and from your job in the most direct route possible. But still, you're going to have to post $100,000 bond.
Your Honor, we would request the lower amount. He's been to court every time. This is multiple times to be here. He's, like I said, he has a good job with the city of Beaumont. He has some sort of, I understand the issue about the alcohol. If we can put some kind of alcohol monitor or something like that on him, but leave the bond at a lower amount so he can continue to work and continue to do what he needs to do to take care of himself.
Anything to say?
Judge, I think the bond that first off, the bond is inadequate. I agree at its current amount. I think the bond that you've raised it to is proper. It's in commensurate with what you've done with other people similarly situated. We agree with the conditions you said. I don't suggest anything lower. I did look on the system here, and I do see that at the time on which specifically, he did have a lawyer representing Mr. Burbank on a misdemeanor offense that arises from the same incident, Judge. So that does explain the.
Well, I'm kind of disappointed that the lawyer wasn't aware that there was a felony offense pending, and he might not have been. But and you were sitting in a misdemeanor court when you should have been in here, but that's not fatal. And those things can happen. But everyone knows a felony offense where you're looking at a minimum of 25 to life is far more important than a maximum of 1 year in the county jail.
Yes, sir.
1 year in the county jail is what you're looking at in a misdemeanor. Life imprisonment on this case. It doesn't take Einstein to figure out where the most serious matter is. But nonetheless, that's not a point here. That's not, the point is the circumstances of this, this underlying, case with his rich criminal history. And then what was the blood alcohol?
157.
Yeah, 157. So that's twice the legal limit, right at twice the legal limit. And it's as though you completely forgot that driving a vehicle while intoxicated has its serious criminal consequences because you were convicted twice before of this. And but you crashed, you were on a motorcycle and crashed your motorcycle.
That's correct. Judge.
Correct?
Yeah. Yes.
So you're out at Cardinal and Finette, a major area, at 11, well, at midnight. This at midnight. And you were honest about it. 3 16-ounce buds is what you admitted to, which may or may not have reached that that high level. And then they brought you to the hospital to get a blood draw. And while they were trying to draw the blood, you were fighting them. They had to put you hand restraints to allow the nurse to draw your blood. You kept resisting from the requirement. It was a search warrant, a court-ordered search warrant that you were objecting to, which is a crime in itself.
That's the misdemeanor he was dealing with, Judge.
And it says a check of his criminal history revealed he was on parole for a DWI 4th conviction. I don't even see that 4th one.
What we were able to obtain is the 2 that's in your indictment, but that's the information from the PC judge.
Okay.
Is that apparently he was on parole at the time of this offense. All of which are factors that the state urges that bond stay at the amount you've set this afternoon.
Okay. The facts show that this is another, there's not much we can really do to prevent him from jumping on a vehicle, a motorcycle, or a 4-wheel vehicle intoxicated. He's making it a career of this. But most importantly, it's your consistent pattern of refusing to follow the rules. And when we're talking about motor vehicles, I mean, people die every day in wrecks for recklessness or negligence in the operation of those vehicles. And that's why the laws are important. These are vehicles are 4,000-pound missiles, nothing more, which can do great tissue damage to people, much less kill them. And motorcycle as well, when it's handled irresponsibly, that is intoxicated and recklessly, it's a danger to you and others. But you have a consistent pattern of not being empathetic toward others. You got to share the roadway responsibly with other people, not recklessly and negligently and irresponsibly. We all have kind of a agreement that we've all reached when we get on the road that we will handle our vehicles responsibly, not only for ourselves, but the other people who rely on us for responsible use. And you don't seem to care about others, much less handling yourself responsibly. So that is the reason for the bond. It is raised for those valid reasons, and we'll put it on the trial docket. You want to try it? We'll try it. And you're looking at, once again, be mindful, no less than 25 years in prison to life in prison. The minimum is 25. And I can tell you the way the juries are, they won't find your criminal history amusing. That is all.
Practice in Chambers County, this would be here around 30.
This is the matter of the state of Michigan versus Timothy Wiedeski, file 25-44601-FY-3. Mr. Wiedeski, we are here for another arraignment. I'm going to tell you what these new charges are, tell you what your rights are, and then we'll discuss the issue of bond. Mr. Fortier, Mr. Brown are here to assist me with that. The new complaint reads as follows. It says, in honor about May the 11th of 2026 in the city of Gaylord and Otsego County, that you did commit the following 5 offenses. Count 1 is charges you with malicious destruction of a building between $1,000 and $20,000. It says that you did willfully and maliciously destroy or injure a building or its connecting pieces called appurtenances located at 825 North Center Avenue that belonged to Munson OMH, and the amount of destruction or damage or injury was $1,000 or more, but less than $20,000, contrary to the Michigan compiled laws. Typically, that would be a felony offense with a penalty of 5 years and or $10,000 fine. However, you're also charged with being a habitual offender, 4th offense, which says that you were previously convicted of 3 or more felonies or attempts to commit felonies. In honor about April 18, 2024, you were convicted of attempted resisting and obstructing a police officer in the 87A District Court for Otsego County in the state of Michigan. On January 9th, 2025, you were convicted of resisting and obstructing a police officer in the 46th Circuit Court for Otsego County in the state of Michigan. In honor about January the 9th, 2025, you were convicted of the offense of resisting and obstructing a police officer in the 46th Circuit Court for Otsego County in the state of Michigan. Therefore, because the underlying offense has a penalty of at least 5 years, the current penalty is moved up to potentially life imprisonment. You understand the name of count 1 to be malicious destruction of a building between $1,000 and $20,000?
Yes, Your Honor.
You understand the maximum possible penalty with the habitual offender is now up to life imprisonment?
Yes, Your Honor.
Count 2 charges you with the offense on the same date and place, the offense of police officer resisting and obstructing. And it says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Daniel Gertz, a police officer of the Gaylord City Police Department who you knew or had reason to know was performing his or her duties contrary to the Michigan compiled laws. That is a felony offense. It has a maximum penalty, would normally have a maximum penalty of 2 years and or a $2,000 fine. However, you're also charged with the same habitual offender 4th offense notice that I previously read to you, with convictions on April 18th and then 2 prior convictions on January the 9th, 2025. Because of that and the underlying felony having a penalty of less than 5 years, the new maximum penalty under the habitual statute is up to 15 years in prison. You understand the name of count 2 to be police officer resisting and obstructing?
Yes, Your Honor.
You understand the new maximum penalty for that offense to be up to 15 years in prison?
Yes, Your Honor.
Count 3 is similar to count 2, charges the same offense involving a different police officer. And it says that you did assault. The name of it is, again, police officer resisting and obstructing. And it says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Jacob Depew, a police officer of the Gaylor City Police Department who you knew or had reason to know was performing his or her duties. Again, normally that would be a 2-year and or $2,000 felony, but because of the habitual offender notice, which is exactly the same as I previously read to you, that 2-year felony level is now increased up to a 15-year felony. Do you understand count 3 to be the name of that to be police officer resisting and obstructing?
Yes, Your Honor.
You understand the maximum penalty under the habitual offender statute has now been increased up to 15 years in prison?
Yes, Your Honor.
Count 4 also charges you with the same offense of police officer resisting and obstructing. It simply changes the name of the police officer involved. And it says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Jacob Kennedy, a police officer of the Michigan State Police who you knew or had reason to know was performing his or her duties. Again, that would normally be a felony offense with a 2-year and or $2,000 maximum penalty. But because of the habitual offender notice, fourth offense notice, which I previously read to you, that penalty is now made life imprisonment, or excuse me, up to 15 years in imprisonment. You understand count 4 to be the name of that to be count 4, police officer resisting and obstructing?
Yes, Your Honor.
You understand the maximum penalty for that offense with the habitual offender to be up to 15 years in prison?
Yes, Your Honor.
Count 5 also charges you with the offense of police officer resisting and obstructing. And it says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Michael Kasdorf, a sheriff or deputy sheriff of the county of Otsego, who you knew or had reason to know was performing his or her duties. Again, that would normally be a felony offense with a maximum penalty of 2 years and or a $2,000 fine. However, you're also charged with habitual fourth offense notice as to this offense, and is the same as I previously read to you. That makes the name of this offense police officer resisting and obstructing. Do you understand that?
Yes, Your Honor.
And do you understand that the maximum possible penalty under the fourth offense habitual offender notice is now up to 15 years in prison?
Yes, Your Honor.
All right. As to all 5 of those charges, you have the right to plead guilty, not guilty, or to stand mute. You have the right to be represented by an attorney, and if you cannot afford an attorney, one would be appointed for you, or you could represent yourself. You also have the right to have a trial before a judge or a jury. If you wish to have a trial, you'd have the right to see, hear, and question all the witnesses against you. You'd have the right to get a subpoena from the court to require your witnesses to appear and testify. At trial, you could testify, or you could choose to remain silent, and that silence could not be used against you. At a trial, you'd also be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. You understand the rights that I've just given to you?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, Your Honor.
Mr. Brown, have you had a chance to speak to Mr. Wadesky about his right to an attorney?
I have, Your Honor. He is requesting an attorney. He would qualify, and I was also informed that his attorney is going to be Richard Trush.
Thank you. I believe that's the same attorney that he has in the other file that we recently opened up against him that I believe I arraigned him on either yesterday or the day before. So I will appoint Mr. Trush as court-appointed counsel in this case. Mr. Wadesky, because you've not had a chance to speak to Mr. Trush yet about these charges, I'm going to enter a not guilty plea on your behalf in order to preserve your right. I'm also going to set a probable cause conference and then a preliminary examination, 2 court hearings, and I'll do that quickly so that your rights are preserved as well. A probable cause conference is a chance for your attorney and the prosecutor's office to get together to try to resolve the matter as quickly as possible. If they're not able to do that, I will also schedule a preliminary examination. That's a short hearing in the district court in front of me as the judge, where the prosecutor is required to bring in a small amount of evidence called probable cause that you've committed the crimes that you've been charged with. It is not a determination of guilt or innocence, but simply a check to make sure that there is some evidence to proceed with the case. Do you have any questions about those hearings?
No, Your Honor.
All right, what we're going to do next then is we're going to turn to the issue of bond, and I'm going to hear from the lawyers. They'll tell me what they recommend, and then I'll give you an opportunity to tell me anything else that you want me to know that would impact bond. Mr. Fortier, your thoughts?
Your Honor, on that other file, he's already got a bond of, I believe it's $50,000 cash surety. So I would leave the issue of how much to put up in this case to the court. I would just ask that the same conditions be ordered, which is no drugs, no alcohol, no marijuana, participate in substance abuse testing or monitoring, and then report via community corrections.
All right, Mr. Brown.
Thank you, Your Honor. I was here for Mr. Wadesky's arraignment a few days ago. This particular complaint, the alleged date of offense is May 11th, so it seems like these are kind of trickling in. So I don't think that while he was out on bond, he committed any new crimes. He does advise me that he is currently a manager at Jet's Pizza. He's been there for about 10 months. He would like to get back to work, not lose his job, as well as it is my understanding he is in the drug court, and the court is very familiar with Mr. Wadesky. So I would ask court to use its discretion in setting a bond in this particular matter, keeping in mind as well that, again, these complaints are kind of trickling in one after the other.
Thank you, Mr. Brown. Mr. Wadesky, I would simply caution you if you're going to make any statements that we are recording this, so I don't want you to say anything about the facts of the underlying cases because that might be used against you to your detriment. However, if there is anything else you want me to know about bond, about your living conditions, your employment, your finances, I'd be happy to listen to that, sir.
Yeah, so I would really like to get back to work and get out of jail, Your Honor. I definitely still have a job. I can get back to work as far as tomorrow. I can start going back to drug court, doing all my drug testing and meeting with Rosario, Kim Murphy at Northern Lights. I can meet with Luke. I can do everything that drug court needs me to do. So I'm very, very monitored still. I'm just not able to do that in here, Your Honor. So if I could get released on a PR bond, I can definitely go to the refuge. I could have a stable place to live, and I could have a stable job, and I can continue to do all the next right things that I need to do.
Thank you, Mr. Wadesky. I appreciate those comments. All right. Just for the record, I am the judge that sits on the sobriety court here in Otsego County, and Mr. Wadesky has been for the last at least a year and a half a member of that sobriety court. So I see him on a regular basis and am familiar with his substance abuse and mental health treatment history. In addition to that, Mr. Wadesky has some misdemeanor history of prior convictions, a number of which were in 2025 and 2024, including a couple of resisting and obstructing in those years. In addition to that, an attempted resisting and obstructing in 21, and some violent offenses of domestic violence in 2017 and 2018, which impact these current charges today. Given his substance abuse and mental health treatment, he is currently, I believe, a danger to the public and a danger to himself, unfortunately. I agree with Mr. Brown. The previous arraignment that we had was for an incident that occurred at the hospital. I believe these charges today involve the same incident. They're just trickling in because they were investigated by different agencies and involved different parties. So I'm not going to necessarily add much to the even though standing alone, these charges might merit a higher bond because of the previous bond and the connection of the incidents. I don't believe that a much higher bond is necessary in this particular case. So I'm going to set a $5,000 cash or surety bond for Mr. Wadesky. Bond conditions will include personally appearing for any scheduled court date, abiding by any judgment of the court, not leaving the state of Michigan without the permission of the court, not committing any crime while on release, immediately notifying the court in writing of any change of address or telephone number, may not use any alcohol, marijuana, or illegal controlled substances, must participate in a substance abuse testing or monitoring program. I'm going to include with that, follow all sobriety court requirements. So
would this be a separate?
I'm sorry, go ahead, Mr. Wadesky.
Would this be a separate $5,000 over the $50,000?
It would. I'm required to set an additional bond, I believe, by the nature of the violent actions that you took. But I normally would have set it at a much higher amount if this was a standalone charge. But because of the other charge and the bond in that case, I reduced this one substantially from what I normally would have, because I recognize that you've already have a high bond in the previous case.
Yes, sir.
Mr. Wadesky will also need to participate in a treatment program. So all his mental health treatment requirements may not purchase or possess a firearm or other dangerous weapon, and must contact community corrections upon his release from the jail and follow all their requirements, because they are the agency that monitors people that are on bond for the court. You have any questions about what's required of you, Mr. Wadesky?
No, Your Honor.
Anything else, Mr. Brown?
No, Your Honor, thank you.
Mr. Fortier?
Nothing further.
All right, that's all for today then. Thank you very much. Good luck to you, Mr. Wadesky.
Oh, good timing, Mr. Kissinger. Next time, don't wear a tank top, okay? Next time, don't wear a tank top,
Oh, sorry. I won't.
okay?
I apologize.
Okay, I don't care, t-shirt, black t-shirt, anything that's not, you know, crude or rude, just no tank tops, okay? All right. I'm gonna do Miss Tucker first, and then I'll get to you, Mr. Pangburn, okay? Actually, you have a 3:30 that I'm seeing. The clerk has to go make a copy, so I will actually do Mr. Kisslinger first, because I don't want to make you late, Mr. Pangburn. So Mr. Kisslinger, just come have a seat.
Thank you.
Nope, she has to make a copy of something for you. What was wrong with your car?
Nothing was wrong with my car. I was at working out in Spooner in time to snoop on.
Oh, okay. I was told your car, but that's okay. Again, I'm going to be lenient today, Mr. Pangburn.
Thank you.
Usually, Mr. Kisslinger is usually very, I mean, he's very respectful to court and in court and all of those things. So that's why I'm being lenient.
I apologize.
I'm sorry, I didn't even fill it out because I didn't order it. So. Oh, yeah, I have just been giving them to people just as a reference. And then if they don't do it, it's on them, because I'm not ordering it, but it's fine. If that's what you want to do, I can start filling them out. We will go on the record in the matters 26 CM05, 26 CM50, State of Wisconsin versus David Kisslinger Sr. The state appears through Assistant District Attorney Jose Vila in person. Mr. Kislinger appears in person with his, Eric Pangburn making a special appearance on Mr. Kislinger's behalf. We're set for, I believe, status conferences. Mr. Pangburn, any update that you can provide to the court?
My understanding from speaking with Mr. Vu yesterday is that there is an offer to resolve this with a plea to a misdemeanor and a fine that requires Mr. Kislinger to complete some treatment. Mr. Vu did reach out to Mr. Kislinger to see what the status of his progress on that was, but he didn't hear back. So I don't know if Mr. Kislinger is able to give us an update today.
All right, Mr. Kislinger, what is your update?
All right, I'm seeing Dave, I was here today. And this mental health, I called up a million places and they said, we don't know why she sends everybody down here for this, but they're not doing it. Yeah. I called them. And I had Dave look up a number 2 for me. I called them and they said, no, we don't do that no more. And I didn't know what to do. I was going to write you a letter on that.
Well, Your Honor, I don't know who Dave is. I apologize. But if he needs assistance finding a place to complete the treatment, certainly Mr. Vu and I can help him. So I don't know if we're able to push this out a little so we can try to find a provider that'll work for Mr. Kislinger.
That is totally fine with me. So you're
I
going
got just a mental health to do.
Yes. Dave is the one who is doing the domestic violence class here. He works here in the county. The mental health assessment, it's news to me that Aurora doesn't do them anymore, our counseling center here. And that's just, the offer was to do a mental health assessment and the domestic violence class. So I can give you more time, Mr. Kislinger. You need to contact either Mr. Pangburn or Mr. Vu, and they can try and help you do a mental health assessment.
I would love that.
And Mr. Vila, again, this is news to me that Aurora doesn't do them, and I'm sure that's news to you.
That is news to me, Your Honor.
So if there's an availability to do a mental health assessment online, would that satisfy the state?
As long as documentation supplied so I can look into it, I'm sure it'd be fine, especially if Attorney Pangborn or Attorney Vu looked into it. I defer to their judgment on that.
Okay, so that should hopefully make it a little bit easier, Mr. Pangburn. So be in contact with either Mr. Pangburn or Mr. Vu, okay?
I don't even know who they are. I mean,
It's your attorney, right there.
All right. For my when I called the cops on myself.
Oh, Mr. Kislinger, that's fine. Mr. Vu called you yesterday. He'll give you another call. So just get back to him. We'll get a hold of you.
Man, 'cause I don't have the money, guys. And
You already paid us. You don't have to worry about that.
You're good to go. Okay, you're good to go. But work with them because they can make this process so much easier, okay?
Okay. Apologize, everybody here.
July 9th at 3 o'clock. Does that work to appear by Zoom, Mr. Pangburn, either for yourself or for Mr. Vu?
Yes.
Okay, July 9th, 3 o'clock. Hopefully you can get everything done by then.
I hope so.
I'm really hoping so, okay? We'll see you then.
All right. Sorry.
Thank you for your help, Your Honor, and for your patience.
Thank you, Mr. Pangburn.
So he's the same attorney I had, right?
Yes, he's your same attorney. We will go on the record. Oh, yeah, it's his birthday today. Happy Warrant birthday present. I think. We'll go on the record in the matter 24 CT 105, State of Wisconsin versus Daniel Bruce. The state appears through Assistant District Attorney Jose Vila in person. Mr. Bruce fails to appear. This matter was scheduled for 3:15. It is now 3:28 and no appearance. He knew to be here from his March 30th, 2026 date in which the court set this hearing time. He is currently still revoked. What is the state requesting?
I would ask for a warrant, Your Honor.
The court will issue a warrant, $250 cash. Only judge may quash or posting of the cash. He will be provided a new date and time upon posting.
Thank you, Your Honor. Have a nice day.
You too, Mr. Bruce. Mr. Bruce, you're late, you're late, you're late for a very important date. I'm gonna say though, this isn't your first time you're late.
There's construction, but that's no excuse.
Do you have a cell phone?
I don't actually.
Did your girlfriend have a cell phone?
She does, yeah.
pick up the phone and call so I know that you're gonna be late, because I warranted you. You have a warrant now,
Oh,
okay?
so I apologize.
I am hoping that you apologize. That's what I was hoping. I will recall your case, okay?
Thank you.
We will go back on the record, 24 CT 105, State of Wisconsin versus Daniel Bruce. Mr. Bruce now appears at 3:34. We have Mr. Vila still here in person. The court is going to quash the warrant. And I don't believe he did not have cash, but the court did order cash on the warrant, but you're not going to have to post the cash. Where are you in the process of getting your license?
I have to reassess for $75 now because of lack of engagement for 2 classes that I missed. But I do believe I can go to the DMV and get a permit now,
Excellent.
which costs money too. So it's just a money financial thing is really kicking my butt.
You think you can get that stuff done by July 9th?
I'm going to try. It's probably your longest case you had.
I want to laugh because it's not.
No. Okay.
But it is a long case. You are correct and you are right.
I'm trying. I'm still trying.
I know. And that's what I like. I like the fact that you're trying and I want you to get your license. This is getting old though, and I'm going to have to cut it loose here soon.
I know.
So, but I want you to get your license. So that means, I don't know, I don't want you to have to rely on your girlfriend or your family or anything, but you need to borrow the money if you need to do those things and you need to get it done because I need to get this resolved. It's 505 days old.
Okay.
Okay.
All right.
So July 9th, 2:45.
245.
What happens if you're late?
I'll be arrested.
Right, because I'm not going to, I won't be lenient next time.
Okay.
Unless there's an issue and you call and you let my assistant know, so I have a heads up.
All right.
Okay?
Okay.
But don't be late.
Sorry.
Not 1 minute.
Not 1 minute.
Okay. We're adjourned.
Hold on. I mean, stay. Don't go anywhere. Hold on. We're ending, but we're not ending. Not really. Hold on. Oh, really? It's like very, very end. Okay. See if I can do this right. Ladies and gentlemen, stand by.
Is there any
Mr. Benson's client that what we would do with value of the
would
Mr. Benson, you think?
Yeah, I'm fine with that. And I know we're looking for an independent appraiser, and my client previously used Nicole Johnson out of Cushing. So I'm thinking we could either use Mike Masterjohn or
This is
Sue
Denver's
Holmquist
fault.
from Gibbons Appraisals out of Grantsburg.
Yep, I'll run both of those past my client, and we can hopefully, get somebody on board here.
Just so you know what we're looking at here. This is supposed to be a follow-up to the crazy sob sit that we saw last week in our court.
tickle this for 90 days to see if I have a review and an update from the parties. And if I don't have an update, then perhaps I will have my assistant schedule another status conference. But hopefully everything can move smoothly and maybe this can resolve.
Yes,
Your Honor,
thank
and
you.
I think the only other thing is I'll maybe put together a stipulation to have Kevin Anderson dismissed from the case based on the agreement reached with my client. So.
All right, that sounds great.
Okay, thank you.
All right, thank you.
Yep,
We're
thank you.
adjourned.
Okay, so your link took me to like 30 seconds before the end of the stream in Discord.
Oh, not since we were broken, but before. Oh yeah, before. All right, so I have Mr. Benson, I have Mr. Anderson. I have Kevin Anderson, and it's Kevin with an E. And
2020.
I have a telephone number. I'm going to guess that's Robin Anderson. Hearing with him, 20 record in the
Here we go. This is the thing. This is the thing Dimmer's talking about. Hi, Judge Mogan. How are you?
We will go on the record in the matters 26 CF 46, 26 TR 306, State of Wisconsin versus Ryan Locke. The state appears through Assistant District Attorney Jose Villa in person. Mr. Locke fails to appear. This matter was scheduled for 2:45. It is 3:22. No appearance. Weather is great and you can drive and get here. There's no weather conditions at all. The court did have a hearing with him on May 21st, 2026, in which he appeared by video conferencing and was being combative and not complying with the court's process. The court ordered him to be here in person today at 2:45. He now fails to appear.
Well, crap.
What is the state requesting?
I would ask for a warrant, Your Honor.
The court will issue a warrant, $2,000 cash. Only judge may quash or posting of the cash. He will be provided a new date and time upon posting. The court is going to find him in default for 26 TR 306, and I will assess $200.50, 3 points off of his license for his failure to appear here today.
Idiot.
We are adjourned. Oh, and the court will forfeit any cash previously posted pursuant to 969.13 of the Wisconsin statutes. Now we're adjourned.
Oh my God. He deserves every bit of it.
The court will go on the record in the matter.
Okay.
Same.
Back to the point.
I won't.
All right.
Okay.
All right.
Okay.
Okay.
Don't be late.
Don't be late.
Sorry.
Ever.
Not 1 minute.
Not 1 minute.
Not 1 minute.
We're adjourned.
We're adjourned. Ladies and gentlemen, that's how you end the show right there. That idiot. He didn't even show up for his own case that he demanded to be in. Oh my God. He's fully in default and he's got a bench warrant. How much more of a moron can you be? What an idiot. He was such a jerk last time we saw him. He couldn't even show up and be a jerk in person. I don't know what I'm doing anymore. There we go. You got to tour through all the screens and still we ended on the right thing. Ladies and gentlemen, thank you for being here. It has been an amazing chat. It's been a really fun show. Thank you for being here. Thank you, old Squishy Gardner, the OG himself, hanging out and chat with us tonight. Thank you for your input. Fat Boy is back as always. Dimmer, Rhonda, and Mama Wolfie, all of you. Love you very much. Y'all have a great night. And while I'm thinking of things to say about all the cool things that happened tonight, I'm going to start these credits right here. I'm just going to read names lackadaisically, like Rhonda Ann, Felix Hoffman, Art. Show goes live. Mama Wolfie, Dimmer, Julie, Piernoth, Shiloh's Fire Art. Just call me Stephen the Kerfuffler. It's too long. I can't say it. It's not like Divine Mystic Whispers. It just rolls off your tongue. Sawadee Wiz. Michael Furberg. Radio Sleeve. That's a good one. Wendy Greek. An amazing name. Oh my God. Metal Rules. I like that name a lot. Living Like a Cat. I know another one of those somewhere around here. Thank you all for being part of the stream. I am your lone wolf. I'm an idiot. I put these court cases together every single day. I watch way too much court, so you don't have to. But hey, it's what I do, and I love doing it. I'm gonna do a lot more of it too. I'll have some standalone videos coming out tomorrow, all day long. These things drop like every 8 hours now. I don't even know what I'm doing anymore. I'm insane. Hey, stay tuned. We're on to share that Hutch link. We're redirecting over to Hutch. We got more court coming. So don't go away, all you crazy court loving people out there, because there's more court to have. And once Hutch is done, Wolfbot playing until I go to bed. So until next time, same Wolf time, same Wolf channel. That's around 8 p.m. Central Time, 9 p.m. Eastern Time every single night of the week, and 11 a.m. noon Eastern on the weekends, on Saturday at least. I take Sunday off, you know. We also have premieres on the weekend, so you can like, comment, subscribe, do all those things that I'm supposed to tell you to do as a YouTuber. I'm just a weird dog guy. I have chihuahuas. The cat that bosses me around and makes me do these streams. I don't know. It's just one of those lives. It's what you do. Until next time, I'm your Lola Fussel. I'm a dog. I'll see you next time. I love you all. Oh, I gotta stop this. We're late for a very important date.